Yes, ready for dictation at the speed of 80 word per minute. 3, 2, 1, start. Mr. Aaron Lohan, learned counsel, would concede that in the event notional interest calculated on the terminal benefits and investments is excluded, the petitioner's family's monthly income would be less than 60% of the last drawn net salary of her husband. Full stop. Therefore, the only issue for consideration is whether the bank was justified in taking such notional interest into account to work out the monthly family income of the deceased employee's family. Full stop. Pertinent to note, the scheme itself provides for monthly interest upon the net corpus of terminal benefits at the bank's maximum term deposit rate being included in the monthly income of the family. Full stop. However, subpara within bracket 6 of para 5 within bracket B does not provide for any such notional interest being worked out on investments and only speaks of monthly income from investments. Full stop. Significantly, identical norms in the scheme floated by the Oriental Bank of Commerce fell for consideration before a learned judge of this court in Srimati Santosh Devi versus Oriental Bank of Commerce and another 2009 within bracket 3 SCT 416 full stop. The petitioner in that case was also denied ex gratia on a similar working out of her family's monthly income after the death of her husband, and the Oriental Bank of Commerce quantified the same at more than 60% of her husband's last drawn net salary. Full stop. The distinction in that scheme and the one presently under consideration is that the Oriental Bank of Commerce did not include pension in the monthly income from all sources, unlike the subject scheme, which does so under subpara within bracket 6 within bracket 5 of para 5 within bracket B. Full stop. Basing on this, the learned judge held that the Oriental Bank of Commerce ought not to have taken into account the family pension drawn by the petitioner in that case while working out her family income from all sources. Full stop. As regards the notional interest worked out upon the net corpus of terminal benefits, the learned judge observed thus. Full stop. In my opinion, the inclusion of such notional interest deemed to have been accrued on the terminal benefits is arbitrary and unreasonable. Full stop. The monthly income on account of interest can be added in the monthly income of the family if the said interest has actually accrued to the family. Full stop. There may be a situation where the family of the deceased employee might have spent that amount on the purchase of house or on the marriage of the children of the deceased employee or for clearing the liabilities of the deceased employee. Full stop. The interest income of the family can be taken into account if actually there is an income from the deposit of the terminal benefits. Full stop. On notion, no deemed income could be taken into consideration. Full stop. Consideredly, it has not been stated by the respondent bank that the petitioner family is actually receiving an amount of interest from the deposit of terminal benefits full stop. Therefore subpara within bracket 6 within bracket small I of para 2 of the revised scheme dated 26/9/2007, which provides for taking into account the deemed interest on the terminal benefits without there being any actual accrual, is illegal, arbitrary, and unreasonable. Over.